because we can document the mail fraud, securities fraud, bankruptcy fraud, unlawful conversion, theft, extortion, and a whole bunch of other stuff. The notary protest process and the notary are the people's court. This is where we get judgment on the real truth. This is the one way we've figured out in all the years that we can determine, we can get judgment on the real facts. We don't care if they respond. If they don't respond, they are agreeing. If they respond in a non-responsive way, if they fail to produce the documents that you insisted on, then that is a non-response, and they are stipulating to the contract as written. This is the people's court. How does it work? What is the actual mechanics of it? On day one, there is a presentment, and the presentment is something that I, as an expert or somebody else, creates. And that is presented to the notary, who presents that with either a subpoena or the notary presentment under seal. And in the process what I'm going to show you here today, we use both of these. Because in most foreclosures, we got two parties. That is the bank and the courts. We will be serving the subpoena, the presentment with the subpoena to the banks, because they have a mandatory obligation to act. We will be sending a notice or presentment to the courts under a notary presentment, because there's not an obligation for them to respond. We're simply putting them on point and saying, now, we are going to document whatever you do next. All right? And we'll show you that. That's day one. Day 16, the notice of dishonor. The second notice goes out. And we're going to be changing that name because it's not really a dishonor. It's their stipulation. They're agreeing to agree. They're agreeing to contract. And we're going to change his name. We're going to tell him, okay, we understand you're about to agree to a contract. You're about to enter into contract. And if this is done by mistake, we're giving you one more opportunity here to rebut and challenge this contract. On day 21, we sent out the final notice, telling them you have 3 days to rebut, and if you don't, you stipulate. On day 28, we issue the declaratory judgment. Now, Article 1 of the UCC says you can accelerate at will. In a 911 situation, in an emergency, we can speed this process up. I have personally witnessed the IRS, and this is the process the IRS uses. I have personally seen them put this and this in the same envelope. All right? And it's valid. It is valid. And we can do the same thing. I have taken in emergency situations, instead of giving them 21 days here, giving them 3 days. Sending these two in an envelope at the same time, the next day. On day 3, you have judgment. Now, it's pushing the envelope, but it is a valid process, and you only use that in emergency. We can accelerate at will. In these foreclosures, we have a problem with timing, because we're so behind the 8 ball, and they are so aggressive in it that we got so many cases that people are on the verge of being thrown out of the house, that their houses are up for auction tomorrow, the next day. Some of these we're going to have to accelerate at will. There's another way we'll show you here shortly that we will absolutely accelerate these at will, and that will be by their actions. When we make these presentments to the bank, and if they take overt steps in the furtherance of this fraud, we will accelerate and issue judgment immediately. I don't care if it's 3 days, 2 days, whatever. We know that they've received it, and they take overt steps. That is complicity, and we will issue the judgment, bam, right then.